We're going to move on to discussions about the invalidation opposition systems in patents at each PO. So first of all, we'll have another presentation by Mr. Yasuda. So next I'd like to talk about invalidation opposition systems in patents. First, I'm going to present some statistics. These are some key statistics. This slide shows the trends, the number of opposition filings and the average time intervals from commencement to disposition for patent evaluation trials and opposition filings. You can see that the trends are flat or down. For oppositions, you can see that the number is quite low. But we've got about 1,000 to 1,200 of these cases. So if you look at the pendency time, the invalidation length of time is increasing. It's probably because of the pandemic. So if you look at the oppositions, you can see that the trend is virtually flat. So this is a comparison between Japan, America, and Europe. This is just the systems are different, but this is just a general idea. So in Europe, it's a two-stage process. So in Europe, there are around 3,000, 3,500 cases. In America, most of the cases are IPR cases. And in Japan, as I've said before, you can see the data here. This is the number of invalidation cases and trends in Japan. It's a little difficult to understand. The dark yellow at the top is invalidation cases, and the grey underneath it is validated patents with corrections, and the beige questions are validated patents without corrections. There's no major trends here, but the proportion of invalidated patents is about 20%. If you again, this is Japan. This is the status of opposition filings in Japan. About 50% of patents are maintained, and about 11 are rejected entirely. Some are maintained without any correction. This is about 37%. So this is a system. These data is from when this opposition system was introduced. As a reference, this is the situation in America and Europe. I'm sure that we may talk about this in more detail later. So the systems in Europe and America are different, so it's hard to compare. But the main system in the US is IPR. But in the case of the EPO, about 1/4 of patents are rejected, which is quite high compared to Japan. If we go back to Japan and look at the number of patent oppositions and the situation here, and this is the technical field. The situation in Japan is that Section C, which is the chemical patents, this accounts for 30% of all opposition. The number of is smaller, but D is also quite large. If we go to Europe and America, in Europe the number of oppositions is highest in chemistry and mechanical engineering, but in America the number of oppositions is largest in electronics and computers. And so the fields in these countries are extremely different from Japan, which I find very interesting. In Japan, this is details about appeals to refusals in Japan. The blue bars here show the number of the overall number of requests. The yellow bars show the number of cases that are actually accepted by the examination board. So obviously you can see the difference between the yellow and the blue bars is the number of cases that are accepted and not accepted. And you can see that the pendency time is about 11.9 months, which has remained flat for the recent period of time. So if you have a look here at the number of successful appeals in this case, the number of cases is increasing, number of successful cases is increasing up to 76.8%. This is an interesting slide that shows the details by nationality, that perhaps non-Japanese patents are rejected in a high proportion of Japanese patents, but actually this is not the case. As you can see here, the blue bars at the bottom show that about 20% of all patents in Japan are applied for by non-Japanese people. The number of the total number of registrations are shown by this grey line. So the difference between the number of registrations and the number of oppositions is quite large. So it shows that the figures are not so difficult. So these are the per nationality combinations of requests and defendants for invalidation in Japan. So about 30% of these requests involve one of the parties is from outside of Japan. So it's not a very large proportion. But on the other hand, this is the number of but per nationality, isn't it? More non-Japanese applicants file appeals against refusals in Japan as opposed to oppositions. So this is because the application procedure is quite expensive, and people want to back up their investment by filing appeals. So if we have a look at the number of decisions, these are the court cases filed against the decisions by the JPO. So if you look at invalidation and oppositions, you can see in blue here. Then the number of court cases is shown in orange compared to the number of oppositions and appeals. It's about 50%, as you can see, compared to oppositions. It's about 80% for oppositions. As a result, as you can see on the right-hand side, the number of decisions that are vacated by the court changes from time to time, but it's about 30% of applications. This slide talks about double tracking in Japan. This is a situation where proceedings are carried out in parallel with the JPO and in the courts. As you can see on the right, the pie chart on the right, this shows which is the fastest, which delivers a decision most earliest. And you can see that the courts are generally faster. And on the left-hand side, in the case of invalidations, and the blue shows when the JPO and the courts are in agreement, and this is about 80%. Both tracks are in agreement with each other, but there's about 20% where the judgments of the two are not the same, and you can see in the smaller pie chart here. So you can see the results here. in the small pie chart, the breakdown of these differences. And about 13%, the dark orange part here, is where the decision of the JPO is finally revoked. Finally, I'd like to move on to corrections. This is going to be the subject of our panel discussion later on. I'm sure that we'll have the details later. But as you know, the correction system in Japan, there are requirements that have to be satisfied. The first, there's these 4 objectives for corrections here. And number 2, as I'm sure this will be a topic of our panel, is that the addition of new matters is prohibited for corrections. But if you look at the the percentage of items that are judged to be new matters, this was an article shown in a journal which showed that of 85 decisions, about 75% of these cases were judged to be not new matters. So which is about a quarter of cases are actually judged to be new matters. So let's just move on to the timing of corrections in invalidation proceedings. In Japan, there are 2 opportunities to file corrections. So first of all, when the patentee receives the duplicate of the request for the invalidation, you can issue a correction then. So, if the decision of the panel goes against the patentee, a preliminary notice is submitted, and that gives you another chance to make a correction. So, in that case, there is a maximum of 2 opportunities to issue a correction. This compares the correction systems in the 3 POs. So, but there's lots of similarities between the 3: the prohibition of new matters and the expansion of the scope of the claims is not permitted in all 3 cases. So the objective, the purpose of claims is a little wider in Japan compared to the USPTO and EPO, and the objective of the 3 is slightly different. So if we have a look at the period in which corrections are possible, in the case of the JPO, as I said, there are multiple opportunities to issue corrections. And there's at least 2 occasions in Japan where you can issue a correction. For the USPTO, you only have less than half a month, and within 3 months of the start of proceedings, you have to issue the correction. And I'm sure for Europe, we're going to hear in our discussion later, after the amendment to the rules in Europe in 2020, the opportunity to make corrections is restricted as the proceedings advance. The number of corrections are permitted. Japan is more than 1, as you can see here. Then finally, to compare corrections, this is an auxiliary request for corrections, which is a second correction stage. It shows that in Europe you can issue an auxiliary correction, but not in Japan or America. Then finally, the relationship between the acceptance of the correction and the final acceptance or rejection of the patent. In Japan, there's no relationship between the correction and the final judgment. In the case of America and the EPO, if the invalidation is concluded as being invalid, then the correction itself will not be accepted. I'm sure that we're going to discuss this issue in further detail later in the panel discussion. Thank you very much. Thank you, Mr. Yasta, for your presentation. So, I'd like to ask Mr. Scott Baldlick of the USPTO to make his presentation.
All right, thank you. So I'll discuss the systems in the USPTO at the Patent Trial and Appeal Board. Starting with appeals, so one thing to know about both appeals and trials at the PTAB is all of our decisions are made by panels of 3 judges. That's required by our statute. And there's no jury, it's 3 judges. The judges are required to have both technical and legal training. For appeals, you can see about a decade ago, we had a very large inventory of appeals. And this had built up rather rapidly starting, by 2010, the number of appeals had been going up pretty steadily for a few years. It really reached its peak around 2012 before we were able to start hiring and to bring the appeal backlog down. You can see that through some tremendous effort by my colleagues at the PTAB, over many years, we're now under 5,000 appeals in our inventory. And that's about where we want to be. This slide shows the pendency of the decided appeals. And it's broken out. The colored bars are by technology, and the overall pendency on the far right with the black bar shows that we're now at an average pendency from the time that the board receives the appeal and dockets it to decision of about 12 months, which has been our goal for a long time. The slightly faded gray bars behind shows what the pendency was a year ago for the same time period. So this happens to be June to August of 2022 in the foreground with the colored bars, and in the background with the gray bars is last year, 2021. You see for most of the technology centers as well as the overall pendency, it's come down. We've had a slight increase in the biotech, not by too much, by about 1 month, but most of the other technologies have come down. So we're very pleased with where the appeal pendency is now compared to where it was. This just gives you an idea of the appeal intake in our fiscal year 2022, what technology centers were the most popular, and you can see that there are 4 categories of electrical and computer appeals. This is broken down by the technology center in the USPTO where the cases are examined. So this maps to the examining core. But you can see that if you add up those 4 blue bars, that is the largest number of appeals, but followed closely by our mechanical and business method appeals, then chemical, then biotech. And then we have a small number of design appeals and also the central re-exam unit. Those are from both re-examination and reissue of already issued patents. So this is another way that issued patents can be reviewed. They can be reviewed in the post-grant trial system that we're about to talk about, but third-party requesters can also request a re-examination. That's been something that has been possible since around 1980, so that's a long-standing way of requesting a review of an issued patent. Appeal outcomes, this is outcomes of appeals at the PTAB. So you can see that the examiner is reversed about 34% of the time completely. There's a partial reversal, partial affirmance in about 9% of our cases, and most of the, with the exception of a few small cases in administrative remands or dismissals, which doesn't happen very often, then the examiners affirmed about 55% of the time. So that just shows you across the board for last year the outcomes of our appeals. This is actually very similar if you look at our prior year statistics. This is very common. It's broken down very similarly in prior years. Now we'll talk about the AIA trial proceedings or post-grant proceedings. There right now are, well, really two main types. There's three active types of AIA proceedings that one can initiate. The first is post-grant review, or PGR. That one has a limited window of time. You only have 9 months from the issuance of a patent to request a PGR, but the number of challenges, the grounds on which you can challenge the patent, are broader than in the inter-parties review, or IPR, which by contrast can be used to challenge a patent at any time during its life after that initial 9-month period. But it can only be challenged on a limited number of grounds, as we'll see in a moment. There's also something called a derivation that is used if someone has derived their invention from another. It's not subject to a lot of the same time constraints that the PGR and IPR are subject to, and there's only a small number of these, but it is another AIA proceeding. There was a fourth kind of proceeding that is now sunset. It was called a covered business method review, but that proceeding has now sunset. No new covered business method reviews can be filed, although there are still a few that may be pending on appeal to the Federal Circuit or on remand from the Federal Circuit, but we're largely done with covered business method reviews. So what is the scope of each of these the two main types of AIA proceedings? So in the IPR, you can only petition based on anticipation or obviousness grounds, what we call 102 or 103, corresponding to the different sections of our statute, and only on the basis of prior art consisting of patents or printed publications. So that's it for an IPR. Post-grant review, you can pretty much petition on almost any ground of invalidity except best modes, or a couple of others like on sale bar and some others that you can't use. The main ones, though, and what this really means practically, is you can have a petition on patentable subject matter, or 101, or some of our written description, or grounds for indefiniteness, what we call Section 112. So those are the more common grounds in the PGR, because it's something you cannot get in an IPR. The standard for initiating review is slightly different between the IPR and the PGR. The IPR is a reasonable likelihood that a petitioner would prevail with respect to one challenge claim. That means that it's maybe 50-50, but it doesn't have to be exactly. It can be close, but the PGR is higher. It's more likely than not that one claim is unpatentable, or there's another way to get a PGR initiated if there's a novel or unsettled legal question important to patents or applications, although that ground is really not very frequently used. The standard of proof is lower than the clear and convincing evidence standard required to prevail in the U.S. District Court. That's by statute, so Congress designed the system so that the PTAB has a lower standard of proof than the District Court. Congress also provided us with some set timelines that we need to meet, including completing our trials within 12 months of institution. They can be extended by 6 months for good cause. But so generally, the entire time of an AIA trial, from the time the petition gets filed to the time that we're done, is about 18 months or less, but it can go slightly longer. The AIA proceedings really go in two main phases. So the first phase, what we call the institution phase, you can see in the red box, and that is about a total of 6 months average from the time a petition's filed till a decision is made to either proceed with a petition, to institute a trial, as we say, or to not institute a trial. If the board decides not to institute, that decision is non-appealable, although that hasn't stopped many parties from attempting to appeal or find some other way to get that decision reviewed by the courts. But if we do institute a trial, we move into the blue box, the trial phase, which includes a portion for amendments, which you heard about a little bit in the prior presentation. There's also a limited discovery period. There's an oral hearing and a final written decision. All of that has to take place within 12 months unless there's good cause, in which case we can extend for up to 6 months that trial phase. So what are the sources of law? First of all, we have our reviewing courts, the U.S. Supreme Court, and our immediate reviewing court, the U.S. Court of Appeals for the Federal Circuit. We have statutes that govern IPRs, PGRs. We have rules that we have put into place for the conduct. We have precedential decisions. We have a trial practice guide that gives guidance to the parties on how to conduct a trial. We also have director guidance and memos that the director can issue, and I talked in the prior time about some of the efforts that Director Vidal has underway right now to try to provide additional clarity in our proceedings. So the outcomes of a proceeding, if we do institute trial and we go all the way to a final written decision, what can happen? Well, really three things. One, we'll find all the claims are patentable, so we uphold each and every challenge claim. There's a mixed result where some challenge claims are upheld, some are not, or all the claims that are challenged are found unpatentable. So that's really the three results. You'll see in just a moment I have a few statistics on this that's available on our website if you'd like to go look. So what can happen, what can a patent owner do if they get an unfavorable final written decision? There's a couple of things they can do. And by the way, a petitioner can have similar options if they get an unfavorable final written decision. So they can ask for panel rehearing. We talked about this previously, but they have to choose panel rehearing or director review. There's also still a proceeding we have that's called a precedential opinion panel. That's another route. Or they can just go and appeal to our reviewing court, the Federal Circuit. So here are some statistics. First of all, and again, as you heard in Mr. Yasuda's presentation, most of our trial proceedings are IPRs. You know, this is looking at fiscal year 22, the recently concluded fiscal year, and you see 96% of our proceedings in that fiscal year are IPRs compared to 4% PGRs. That's on par with prior years, again, by technology, and you heard about this in the prior presentation. Most are electrical or computer inventions. This is, again, the last fiscal year. This just shows you month by month from August of 2022 through the prior 12 months, what our filings are like. And again, you can see they're pretty steady month to month. There are some variations, but largely steady in IPR and PGR filings, but at very different levels. Here are just the last 5 years of institution rate. So this went through August. Of course, fiscal year 2022 did conclude, but by the time I turned in the slides, it hadn't quite wrapped up. But you can see that our institution rate, this is where we decide to grant a trial or not, has been in the 60% range. It's dipped down to about 56%. It was 66% as of the time of this slide. Believe it ended up at about that. This is if you count by patents. There's a couple of different ways to count. You can count by petition, or because it's possible to submit more than one petition challenging a patent, you can also just count by patent. You see that the institution rates are similar, although slightly higher if you count by patent, which isn't surprising because, again, there can be more than one challenge. Although typically it's very rare to have more than one. More than two is extremely rare. So most of the time you have one or two challenges per patent. This is just a comparison of the last two slides, the institution rates, if you look at it by petition or by patent. Also by technology, this is another way to look, is the institution rate. By technology. This varies year to year. So sometimes the biopharma is instituted less, but last year it ended up being instituted slightly more than the other technologies. Settlements, you can see that our settlement rate is fairly steady, between about 25 to 30% overall. This graph is broken out by pre- and post-institution settlement numbers, and you can see they're roughly equal between pre-institution and post, although usually if one's going to be greater than the other, there tend to be more post-institution settlements than pre-institution. And lastly, I'm just going to show you a few outcome slides. These are all available on our website, but what you're looking at here is, again, in fiscal year 2022 through the end of the third quarter, you can see there were 993 total petitions filed. Of those, nearly 1/3 were denied. That's the orange slice, where we did not proceed on to a trial. About 25% settled, although if you look at other ways that the petition didn't make it to a final written decision, you can see there's another about 6%. So roughly 2/3 of the petitions filed never make it to a final written decision. Only about 1/3 of the petitions ever filed go all the way to a final written decision. And then those three blue slices show you the proportion of the three outcomes. So 25% had all of the challenged claims found unpatentable. 6% had a mixed outcome, and 6% had all of the challenged claims being found patentable. So this is a view by petition. As I said, there are different ways to count. I'll quickly show you two more ways to visualize it. One is by patent, and you can see just visually the outcomes are very similar, with approximately 1/3 of institutions being denied, slightly less than that, slightly less than 1/3 settled, and slightly more than 1/3 going all the way to final written decision, shown by the three shades of blue. But again, the total proportions are on par with the outcomes if you count by petition. And the last view I'm going to show you is just outcomes by challenged claims. So this just looks at claims challenged. You can see that in the first 3 quarters, there were almost 15,000 claims that were challenged. And once again, about 1/3 were denied institution. About 1/3 or less had settled in some form. They never reached final written decision. Only a little bit more than 1/3 ever reached final decision, and as of after the final written decision, about 9% were found patentable, about 30% unpatentable. So that's just sort of a snapshot of the outcomes of the IPRs, and so that concludes my presentation. Thank you again for your attention.
Thank you very much, Patent Judge Borick. And next speaker is Dr. Ingo Beckodorf, Chairman of the Technical Board of Appeal, European Patent Office. Please start.
Thank you very much again, and I will try to keep the time, and therefore I might skip a couple of slides. Starting immediately with the legal basis for the appeal proceedings, I will cover slightly different topics than my two predecessors, for a simple reason because the appeal proceedings before the EPO under the EPC are a bit different, and allow me to explain why this is the case. First of all, the legal basis for the boards of appeal and their proceedings are Article 4 and Article 15 of the European Patent Convention, the EPC. In Article 4, you see that the European Patent Organization has two organs. That's the European Patent Office and the Administrative Council. The European Patent Office is the one of which the boards of appeal are part of, but they are a bit separate, not completely separate, but they are separate and with a degree of independence. And we are mentioned then also in Article 15 of the European Patent Convention. You see there the litera F and G, the boards of appeal and the enlarged board of appeal, coming after the different sections and divisions of the what I call the administrative part of the European Patent Office. Now coming to the appeal structure. What you can see here, you have the line in the middle, the horizontal line in the middle. Below that line, you see the administrative part of the patent grant procedure. That is within the patent office, within the different sections and divisions of the patent office. I'm not explaining the different bodies there, but I think the names are already clear. Receiving section, examining section to decide on grant, opposition divisions to decide after grant, and the legal division for some legal aspects. All their decisions can be appealed to the boards of appeal, being the first and final judicial division instance under the European Patent Convention. That distinguishes us a bit from what you just heard about the JPO and the US Patent Office. We have no further appeal. We have the appeals heard before the boards of appeal, be it the legal board of appeal, the technical boards of appeal, and then the enlarged board of appeal with a specific composition and specific competence to which I will refer on a later slide. Again, there's no further appeal, and even after the coming into force of the Unified Patent Court that Dr. Bacher mentioned yesterday to be next year, become next year the reality, what we call the UPC is not a higher court above the boards of appeal, but it's a parallel court. That means additional challenges for us to avoid that there's any fundamental difference in our case law. The internal structure of the boards of appeal, you can see here. We have a president of the boards of appeal as the head administrative, but also judicial head of the boards of appeal. And then we have the different boards. The enlarged board I already mentioned, the legal board as well. 28 technical boards of appeal. They divided into 4 main technical sections: mechanics, chemistry, electricity, and physics. And then we have a specific specific board, that's the disciplinary board of appeal, that I will mention only very briefly. This hears appeals from candidates to become patent attorneys and who failed to pass their exams, their qualifying examinations to become patent attorneys before the EPO, or even some disciplinary actions against patent attorneys. And we have a couple of administrative services, of which I mentioned in particular the legal service, consisting of legal advice to the President of the Boards of Appeal and the legal research. That's the one that might be well known to the users because they publish what we call the case law book. I will come to that in a later stage as well. The technical boards of appeal, they consist of either 3 technical members plus a legally qualified member, or in an extended composition of 3 technical members and 2 legally qualified members. They hear appeals against decisions of the examining divisions refusing a patent applications, or decisions of the opposition divisions, either by revoking the patent, by dismissing, rejecting an opposition or several oppositions filed against an appeal, or by what we call interlocutory decisions, where the patent was held to meet the requirements of the EPC in amended form, i.e. in different form than the form in which the patent was granted. Here we have per board an average of, in 2021, of 121 cases. A board usually consists of 1 chairperson. The majority of the technical boards are chaired by a technically qualified member, with 4-5 technically qualified members, and 2 technical boards are chaired by a legally qualified member, of which I am one. And here we achieved an increase in our production over the last 5 years, by 55%. The Legal Board of Appeal hears appeals against the legal division when it comes from missing time frames, or for a case that was well known, whether artificial intelligence can be an inventor, an applicant of a patent convention. There was a decision, or 2 decisions rather, published in summer this year. The Legal Board consists of 3 legally qualified members. Those legally qualified members are at the same time also members of technical boards of appeal. The number of cases settled by the legal board is rather low due to the lower incoming number of appeals. The disciplinary board of appeal I skipped because I already mentioned the competence of it, and now I come to the enlarged board of appeal. The enlarged board of appeal is responsible for deciding on points of law referred to it either by a board of appeal or by the president of the boards of appeal, and also since the coming into force of the first reform of the EPC 2000, on so-called petitions for review. First of all, on the referrals, what we call the referrals, where points of law are referred to the enlarged board of appeal when it comes to the interpretation of the EPC. Again, this can be done by a board or by the president of the EPO, and in that case, the enlarged board consists of 5 technically qualified members and 5 legally qualified members and 2 technically qualified members. Among those 5 legally qualified members, there can be up to 2 national judges, what we call external legally qualified members. That's something that we use quite frequently, to have at least 1 external member also in the composition, to allow a better harmonization of the patent law beyond the borders of the European Patent Office, and to try to harmonize also the application of the patent law of the EPC in the contracting stage. Currently, we have 3 pending petitions, 3 pending referrals. That's a referral on the issue of plausibility of a claimed technical effect, and the 2 other ones, the G1 of 22 and G2 of 22, concern the right to priority. They are still pending, but at least in the first one, the case G2 of 21, the oral proceedings will be held on 24th of November, and they will be streamed so everybody worldwide could follow the oral proceedings in that case. In last year, we decided 3 cases. Among those is the one that I already mentioned in my first presentation on oral proceedings by video conference, but there were also 2 decisions on substantive patent law, on the patentability of computer-implemented simulation, and also on double patenting. And the pending cases I've already mentioned. The petition for review, that's something that was introduced in the year 2000 and came into force in December 2007. This is some system of internal correction where in the proceedings, in the appeal proceedings, a fundamental procedural violation occurred. Somebody was not given its full right to be heard. A request has been overseen for whatever reason. Then the party concerned can file a petition for review to ask the enlarged Board of Appeal to review on procedural issues the appeal procedure, and then either to set aside the decision of that board. Usually any decision of a technical Board of Appeal, of the legal Board of Appeal, are final with a legal effect, directly with a legal effect, but with this petition for review proceedings, the enlarged board can set aside that legal effect and can reopen the proceedings before the board. There are a number of reasons why this can be done. The majority of cases is decided on the question of whether or not the procedural right to be heard has been observed by a board or not. In these proceedings, the enlarged board is composed of 2 legally qualified members and 1 technically qualified member, or in an extended composition by 2 extra additional legally qualified members, making then the combination of 5 members. We have a 2-stage procedure here to first filter to see whether there's any substance in the petition of review heard by the 3-member composition, or if that composition considers that there is substance, then the case will be transferred to a composition with 5 members. Last year we settled 12 cases in this case. The overall figures here, we in 2021 we received 2,200 appeals. We were able to settle more, fortunately, due to the overall circumstances, I already gave you the figures of the pending cases this year, even below the 7,000 threshold. And you see again what I mentioned earlier, that there's still an issue with the pendency time. And if I may, from a personal point of view, if I may say so, I'm a bit jealous when I heard the pendency time before the JPO Trial and Appeals Division and before the PTAB, but at least we understood the story and we understood the message, and we are striving to settle that. We have 256 members staff in total, and that means that the majority of which are members, what we call our judges, we call them members, legally qualified, technically qualified, 28 chairs, and then also the president of the Boards of Appeal. Now let's move to the aspects of the appeal procedure. I start on the upper row with the filing of appeal. Before the filing of appeal, if you remember one of my earlier slides with the difference between the administrative stage of the patent grant procedure before the administrative divisions of the EPO, and then only on a second level the appeal proceedings, we are now on the second level. This procedure starts with the filing of the appeal, for which there is a time limit of 2 months after the notification of the decision of the examining division, opposition division, or of the legal division. And then only in what we call ex parte proceedings, i.e. appeals against a refusal of the grant of the patent by the examining division. An examining division is demanded, is requested under the EPC to review its decision internally before the case is transferred to the boards of appeal, because the examining division might identify any problem, be it a procedural problem or a problem on the substance of the case, and might take the case again to continue the examination. After that, and for all opposition appeals directly to the appeal boards, then we do an admissibility check for observing the time limits, for paying the right amount of fee, for being a party to the proceedings, and so on. And after that is done, the examination of the appeal on its merits, on its substance starts. And in the majority of cases, this includes also an oral hearing before the boards. So after the oral hearings, or actually in the almost 100% of the cases, the decision, the order of the decision is already announced at the end of the oral proceedings, and only afterwards the fully reasoned decision will be notified to the parties, and potentially with the additional petition for review if a petition for review is filed at all. We work now under a new version of the rules of procedure. We call it the revised version of the rules of procedure 2022 that I mentioned earlier. So I will try to concentrate only on the important points and how they influence the processing of an appeal before the boards of appeal. When this revision was adopted by the boards of appeal committee and approved by the administrative council, there were in particular three main objects: to increase the efficiency of the processing procedures before the boards of appeal, to harmonize the case law, and in particular to make our case law, our decisions more predictable to the parties, so that the parties can adapt their procedural strategy to come to the outcome they would like to see. All these three objects surround the overall objective of having a high quality of our decisions. So I'm trying to skip now a couple of pages. I can start with this page and also the next page, and I will try to put everything on information on this slide. As I already said, this revised version came into force on January 1st, 2020. We had a couple of transitional provisions to deal with those cases that were filed before that date, but were then dealt with after that date. A first measure to make our processing more predictable is the publication of an annual list. Every year, every October, we publish the list of the future cases for the next business year. i.e. this month we publish the cases that are to be dealt with in the next year, 2023, to allow the parties to already prepare that their case is now due to be dealt with before the Board of Appeal. What has been underlined there as well, that the proceedings before the Boards of Appeal are a judicial review, or review in judicial member. It should not be a repetition of what has been done before the examining divisions, before the opposition divisions, i.e. before the examiners, but we review what has been decided there, and this gives limitations to what the parties can do before us as well. Already to say at this point in time, this does not exclude filing new requests, does not exclude to file what we call auxiliary requests from the side of the patent proprietor. This can be done throughout the proceedings, also before the Boards of Appeal, but the later it comes, the later the filing comes, the more difficult it will be for a party, for a patent proprietor or an applicant to get those new requests being admitted into the proceedings. But this is also true for the other side, for the opponents. They have to stick to what they submitted before before the examining divisions, before the oppositions divisions, and should not amend their case vis-à-vis the proceedings before the opposition proceedings. However, they can do that. And again, as a kind of guideline, the later they do, the more difficult it becomes to get it admitted into the proceedings. And the last new point that I would like to mention on this slide is that the boards are now asked, under the revised version of the Rules of Procedure, to issue a communication when summoning to oral proceedings in order to inform the parties of the assessment of the case by the Board of Appeal, to allow the parties to react to it at the oral proceedings, to inform the board whether on which points they disagree, and to concentrate the oral proceedings on these issues. So then I go through, because just check that I haven't forgotten anything. And that was done. Last sentence. The proceedings end either with a decision rejecting the appeal, allowing the appeal, for example, by revoking the patent, by dismissing the appeal, or the case can be remitted to the Department of First Instance, to the EPO department, either to continue with the proceedings there for further decision, or with the order that the patent should be maintained in a specific form that the board finds to meet the requirements of the EPC. It's not the board that does the publication. It is then the office that does so. So, and that's it. Thank you so much. On the last slide, you will only see some information where some links where you can find more information. Thank you so much.
Chairman Beckdorf, thank you very much. With this speech, we conclude the latest development in the following section.